Our fourth element is legality. A contract to do something that is prohibited by statute or public policy is illegal and unenforceable. Section objectives. This time is very easy because there's only one. To recall the legal effect of entering into a contract for an illegal purpose. So now we have to talk. Some contracts are illegal because they're contrary to statute. Specifically, usury, gambling, violation of Sabbath laws, and engaging in business without a license. Now we're going to talk about them one at a time. You start off with usury. Usury statutes place a ceiling on the rates of interest that can be charged on a loan. As a general rule, 25% per year is the maximum amount to be charged on a loan. Now notice, as a general rule, there are some exceptions. What we're referring to here are consumer loans. Now, there are special loans where the interest rates are higher, but we're not going to cover those. Now, the purpose of a usury statute is to prevent indentured servitude. Now, for those of you who don't know what an indentured servant is, that's one step above being a slave. One of the things that a lot of people don't realize is most of the early immigrants to the United States were indentured servants. They couldn't afford to pay their passage to come to the New World, so they agreed that if a company sent them over, they would work for them for 5 years or 10 years to pay off their passage. That made them an indentured servant, a virtual slave, up until their debt was paid off. Well, the idea about usury statutes is as follows. 25% interest a year is a lot, but it's doable. When a bank lends you money, the bank makes money on that loan by charging interest. Now, many people only pay the minimum rate, and when you only pay the minimum rate, the minimum payment due, primarily you're just paying interest on the loan, right? Most of the money goes to interest, a smaller percentage of the money goes to the principal. So what happens? The loan lasts for a much longer period of time. Well, it's conceivable that if I set a high enough interest rate on the loan, you could never pay me off, right? For example, 100% interest. I lend you $1,000 today. You owe me $2,000 next week. Well, if you don't have the $2,000, right, you'll make a small payment, right? So let's say you pay me $200. Well, that goes to that 100% interest, hasn't touched the principal, so it keeps on growing, right? Conceivably, you borrow $1,000 from me with 100% interest per year. You would never pay that loan off. You would work for me forever. You'd be a virtual slave. Usury statutes are designed to prevent that. Next, we have gambling. All states regulate gambling. What this means is only state authorized gambling is legal. Now, this is really, really important because a lot of us don't realize that, generally speaking, the federal government is silent with regard to gambling, with the exception being the Internal Revenue Service. Right? The IRS says if you gamble and win, you have to count those winnings as earnings and pay taxes on them. This is the reason why, going back, I guess, to the 70s and the 80s, you had states that were called dry states, no gambling, no alcohol. But these states had Native Americans living in them on Native American lands, reservations, as it were. Well, an opportunity arose. Since the Native American reservations are a nation within a nation, they have to follow federal law, not state law. Now, this gave them a very interesting opportunity. The state they were located in, let's say Mississippi, said gambling was illegal. The federal government didn't say anything about it. So the Native Americans could and did open up casinos right on their tribal lands. Those casinos were subject to federal law, not state law. Now, the state always regulates gambling when they can. So if you're not a Native American living on a reservation, right, if you do not have a permit from the state, you cannot gamble. So that means while in New York State, we can go to the racetrack and we can bet. If I were to have a high stakes poker game at my house, that wouldn't be legal. Betting on horses at a track legal, playing cards with me at home illegal. Why? The racetrack has a license, I do not. Following gambling will be Sabbath laws. Sabbath laws prohibit the formation or performance of certain contracts on Sunday. Some make all Sunday contracts illegal. Others prohibit the sale of merchandise, in particular alcoholic beverages. Now, there's something that should be going off in your head, a real big alarm, ding, ding, ding. Sabbath laws violate the First Amendment of the Constitution. So Sabbath laws are unconstitutional on their face. Why? Sabbath laws are Sunday closing laws. Which religion uses Sunday as its day of worship? Now, I'm sure you guys know the answer, but I'm going to say it anyway, right? For the most part, Christians go to church on Sundays. Jews go to their temple, the synagogue on Saturdays, Muslims on Fridays. Other religions pick other days. So in saying that you can't do business on Sunday, what has the government done? It's placed Christianity ahead of all other religions. So a question that you're probably asking is, why are these laws still in effect? Well, first reason would be in order to bring a lawsuit to prevent Sabbath laws, you would have to have standing, simply meaning that the law would have to impact you directly, and the remedy that you're requesting is something that the court could provide. Well, for the most part, jurisdictions that have Sabbath laws in effect, and you notice I said jurisdictions, not states, have populations that are happy with things being closed on Saturday. Right? Take Bergen County, New Jersey, for example. A lot of great malls in Bergen County. Guess what day the malls are not open? Sunday. If you're in Bergen County on a Sunday, what can you do? Well, if you have to stay overnight, the hotels are open. If you're driving your car and you run out of gas, you can buy gas because the gas stations are open. If you get sick, you can go to the hospital because hospitals are open. And if you get hungry, you can go to a restaurant because restaurants are open. But that is it. In Bergen County, New Jersey, on Sundays, you cannot engage in any contracts for anything other than those essentials I just mentioned: food, shelter, medical care, and fuel. Now, nobody in Bergen County challenged it because they probably like having Sundays off. Now, if you look at a state, or not a state, but if you look at a city like New York City, you'll probably notice that while we do have Sabbath laws in effect, they're very, very fluid. There's certain industries, certain types of businesses like liquor stores, that when I was growing up had to be closed on Sundays, period. In fact, when I was a little boy, you couldn't even buy beer in the supermarket on a Sunday. Then when I was about 5 or 6 years old, the laws changed and you were allowed to buy beer after 12 noon, right? The idea was back in those days that on Sundays you're supposed to be in church. However, most people go to church early in the morning. Football games, baseball games play Sunday afternoons. So on your way home from church, you could get a beer so you could have some beer while watching the games. Well, since I was 6 years old, the demographics of the city have changed dramatically. And we have all these other folks in that worship other religions. So what did New York City do in response? They said, well, you can only be open for 6 out of the 7 days. We're not going to tell you which day to close. You get to pick that yourself. So the result is, you have liquor stores that are primarily Christian communities. The owners of the stores choose to be closed on Sundays. If you have liquor stores in primarily Jewish communities, the owners choose to have them closed on Saturdays. It is up to the owners, not the state, right? So the Sabbath laws remain intact and the people's wishes are followed. But once again, just to be clear, with regard to a Sabbath law, the thing that you must remember is the law that's in place where you enter the contract is more important than the law that is in place where the contract is executed. The law that's in place where you enter the contract determines whether or not the contract is legal. Going back to Bergen County, let's say you happen to be the greatest house painter in the tri-state area, New York, New Jersey, and Connecticut. I have a townhouse in Brooklyn, New York. I want you to come and paint my house because you're the best, I'm the best, I deserve the best. But because I'm one of the best people in New York City, I'm busy every day but Sunday. But I just happen to be in Bergen County on a Sunday, and you meet with me to discuss painting my house. We enter into a contract where the next week, on Sunday when I'm free once again, you're going to come to Brooklyn, New York from Bergen County, New Jersey, and paint my house. Question I would have for you is, would that contract be legal? Now, the answer I'm sure you reached is that the contract is not. Why? Because it was illegal to enter into that type of contract in Bergen County, New Jersey on Sunday as per the Sabbath laws of that county. Doesn't matter that you're going to paint my house the following Sunday in Brooklyn, New York, where we did not have any such prohibition. What controlled was where you entered into the contract. Now, if we flip it around, your office is in Brooklyn, New York. My house is in Bergen County. I meet you in Brooklyn on Sunday to enter into a contract to paint my house in Bergen County, New Jersey the following Sunday. Because New York does not have a Sabbath law that prohibits engaging in business on Sunday, that contract would be enforceable, even though Bergen County, where you're going to paint the house on Sunday, says you cannot enter into a contract on the Sabbath. Why? What controls once again? Not where the contract is executed, but where the contract is formed. Now, lastly, we have licensing statutes. All states require certain professions to obtain licenses. When a person contracts with an unlicensed individual, the contract may not be enforceable depending on the underlying purpose of the licensing requirement. Now, notice the phrase is may not be. We're going to come back to that. If the purpose of the statute is to raise revenue, the contract will normally be enforceable. However, if the purpose is to protect the public from unlicensed practitioners, the contract will be unenforceable. Now, this might seem a little confusing, but only until you think about it just a little bit. What kind of licenses would a government issue a city or a state to raise revenue? Well, it would be something that did not impact on a person's health or safety. Right around the college, you have all these vendors that are selling books, tour guides for the World Trade Center area. You also have people who are conducting tours. Well, if you look at those folks, all of them have something around their neck. It's a license so that the cops can see right away they are authorized to sell those guides or conduct those tours. Now, here's the thing. If you were to go and buy a tour guide, tour guide, by guide I mean book, from someone who didn't have a license, what's the worst thing that could happen to you? Maybe you get a book that's not written that well, a book that falls apart, but your health and safety was not in line. So if you went to one of these folks that printed up 100 books, didn't have a license to do it, and you bought the books from them, and then you said, ha, because you don't have a license to run this printing plant, I don't have to pay you for them. If they sued you for breach of contract, they would win. Why? In order to prevent you from being unjustly enriched, the court would order you to pay them for the work that they did. Now, because they were engaged in business illegally, the courts would also fine them. And generally speaking, the fine they would have to pay the government would be less than the amount you owe them, right? And that's fair. Now, you contrast this from a license that's issued to protect the public, right? Maybe a doctor, a lawyer, a stockbroker, a certified public engineer, a certified public accountant. You think about these people. When the court issues a license to a doctor, a lawyer, or an accountant, they're not telling you that this is a good doctor, lawyer, or accountant. They're telling you that they've met some minimum requirement so that they should know what they're doing. Now, if a doctor doesn't meet a minimum requirement, proving that he or she knows what they're doing, what could happen? People could die. If a lawyer doesn't have a license saying they've met some minimum level of competence, what could happen? They represent you in trial for stealing a loaf of bread that was worth $5 and you end up in jail for 25 years. Right? One is your life, the second is your liberty. You look at an accountant, right, who you go to do your taxes. If they don't know what they're doing and they make a lot of mistakes, take bad deductions, and you get audited, you could stand to lose your property because the state could just take it, the government, or your liberty because in some cases they would put you in jail. Right? These are all considered public safety. Public safety. Also under the banner of legality, you have contracts contrary to public policy. Some contracts are illegal, not because they are wrong in of themselves, but rather because they are contrary to public policy. These contracts include contracts in restraint of trade, covenants not to compete, unconscionable contracts or clauses, and exculpatory clauses. Contracts and restraint of trade. Contracts and restraint of trade, also called price fixing agreements, adversely affect the public because they inhibit competition. Imagine you had 3 supermarkets in your community, and the owners of all 3 stores decided to price every item in the stores at the same price. What choice would you have other than to pay whatever amount they were asking for anything? And because you have no choice, guess what they could do? They could raise the prices as high as they want. Now, when I was a kid, I remember growing up in my neighborhood, we had about 4 supermarkets. Now I'm thinking about it, 5. And pretty much every Saturday morning when I go shopping with my mom, we would go to all 5 supermarkets. Why? Because each one ran sales on different things every week, trying to attract customers. Now, because they were competing for the same customers, right, what was the boon for the customers? You got the best quality food at the best possible price, right? You might get canned goods at one store and meat at another store and vegetables at another store this week, and the next week, because the other stores wanted the business, it would flip. But every week, you got the highest quality food at the best possible prices. Now, in the first scenario where they all agreed to the same price, you could actually end up with very low quality food for very high prices. So price fixing agreements are illegal because they inhibit competition. It's not fair to the public. You know what else they do? Generally, they violate antitrust laws. Now, I'm sure you guys remember antitrust laws were put into place to prevent monopolies from coming into being. Right? This happened during the latter part of the 19th century when you had giant companies like Standard Oil that basically controlled the entire oil market in the country. They could set whatever price they wanted. And consumers and the government, who also needed oil, was subject to their dictates. Well, because it was not fair, the government said you cannot do this and you have to let the market decide. Now, I'm sure you guys all understand what a free market economy is. Adam Smith, father of capitalism, right? When you let the market determine the price, there's always an equilibrium between supply and demand, between quality and savings, right? The consumer always decides, right? So the market goes up and down, but it's controlled by the participants, the people that want to buy what you're selling. And generally, as a manufacturer, you have one or two choices. You can sell something high quality for a high price, but you're not going to sell that much. You can sell something of lower quality at a lower price, but you're not going to profit that much. Or you could be somewhere in the middle where you have a reasonable amount of quality at a reasonable price, and you'll probably profit the most, right? That's a free market economy. Consumers decide what they're willing to pay for, so consumers, in fact, control the quality of what they're getting. Now, with this said, there are some situations where you have natural monopolies, right? Where the most efficient way, the most cost-effective way to get goods to the public are by letting one actor control the market. In New York, the real big example will be the MTA and Con Edison. Think about this. When I think of MTA, I focus on trains. Could you have train companies competing with the MTA in New York City? The answer is probably not, because where do you put the trains? There are only so many places you can put tunnels. There are only so many places you can have elevated trains. There is no place to put the trains. From a practical standpoint, the only way to deliver this service is to let there be one actor. Then you think about a company like Con Edison, the electric company. Could you have other companies? You probably could, but once again, infrastructure comes into place. Where would you put the connections between the power plant and the consumer? How many lines from electric companies could you have coming into a given building? Where would you put the lines? In the sky, under the ground? Once again, where would they go? So the most efficient way, due to limitations, is to have one actor. That's practical. If you have multiple actors, and in fact we do, right? Some of you may have gotten involved with energy companies that say they're going to save you money by charging you less. Well, guess what happens? You pay them for the power, but then they have to pay Con Edison to use the Con Edison lines to deliver the power to you. So while in fact you're paying them less, you're also paying Con Edison, so you end up paying more, right? The way to give consumers the best price is to have just one actor in the market. But once again, this has a very limited application. And where you see it, like with Con Edison and the MTA, they are subject to a high level of government oversight. Now, with the MTA, it doesn't seem to work the way it should, because every time they want to raise the fares, they have a hearing. And every time they have a hearing, the public says, no, 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 the service is not that good, but they raise the fares anyway. That's true. They win, because we have no choice. But you look at a company like Con Edison, if they want to raise the rates by a fraction of a penny, they have to justify in extreme detail why that increase is necessary. And most of the time, they don't get to make it. Covenants not to compete. A covenant not to compete is a clause in a contract that prohibits a party from engaging in the same or similar business for a specified period of time over a specified geographic area. Covenants not to compete are enforceable as long as they are reasonable with regard to time and geographic scope. Now, you have two basic uses of covenants not to compete. A covenant not to compete is often used in a contract for the sale of an ongoing business. This enables the seller to sell and the buyer to buy the goodwill and reputation of a business. Now, one of the things that you may notice in your neighborhood, if a bodega or cleaners or pizza parlor sold, frequently they don't change the name. All they do is put up a little sign that you may or may not notice that says under new management, right? Why? Because what are you really selling? You're selling your customers. What are they really buying? Your goodwill that you built with the customers and your reputation for providing a quality good or service. Now, with a covenant not to compete in this instance, the seller agrees not to initiate a similar business within a certain area for a specified period of time. The time and the area must be reasonable for this to work. Now, I want you to think about a bodega. When I was growing up on 109th Street and Columbus Avenue, we have 4 bodegas, one on each corner directly across the street from them. And you know what's really funny? Very rarely did we cross the street to go to another bodega other than our bodega. Why? Because that was my mom's bodega, that was my grandmother's bodega, and when you would walk in, you wouldn't have to say anything. I walked through the door, right, and Manny, the owner, would say, "Ron, I got your sandwich coming up." Wouldn't have to say anything because they knew me. And on the days that I did not have money to pay, you know what they would do? They would sell me my sandwiches, they'd sell me my coffee, they'd sell me my sodas, and they put it in a little black book, what I bought, how much it was, and then at the end of the week when I got paid, I would go in and pay them for what I got. I always got credit. This was my store, my people. Now let's say you're looking at my bodega on 109th Street and Columbus Avenue, and you notice that it's always full of people are coming and going. You sit there for a couple of days and you see they got all these repeat customers. So you pull the tax records and you see that the company's been very, very profitable, made quite a bit of money. So you walk in and you start talking to Manny and you offer him $3 million to buy his bodega. He sells and you take over, put that little sign in the window under new management. Now in the sales contract, you forgot to include a covenant not to compete. So Manny goes on vacation. He takes about 3 weeks. He comes back, and then he begins to construct a super bodega across the street from the one he just sold you. Now, when he finishes, guess what happens? Everybody who knew Manny goes across the street to shop with Manny. They knew him. They don't know you. And the super bodega that he built based on the money you paid him is way better than the store you bought from him. More stuff, better stuff, and Manny. Now, had you been smart, you would have had a covenant not to compete clause in that sales contract, and it would have said, you may not open up a bodega or similar business in a 20-block radius for 2 years. Now, 20 blocks, not that far, right? So you can't put anything on 109th Street, but you put anything on 89th Street, not that far. 2 years, not that long. But here's the thing. How many people would walk a mile, would walk 20 blocks for a sandwich? Not that many. And if, in fact, Manny came back 2 years after you bought the bodega, the people know you now. They've forgotten about Manny. So he wouldn't be able to steal the goodwill or take the goodwill that you bought from him. Right? Very, very important thing to include in the purchase of an existing business. The second use of a covenant not to compete is with an employment contract. An employer may stipulate in an employment contract that upon the termination of employment, an employee may not engage in the same or similar business for a specified period of time over a specified geographic area. Let's say you graduate from law school and you come to work at my firm. In that employment contract, I have a clause that states, upon your termination of employment from this firm, you may not open up a legal or related practice in a 5-mile radius of this office for 5 years. Now, this is designed to protect me from you poaching my clients. Think about this. When you graduate from law school, what do you know? You know the law. You know how to research. You know how to write. You know how to argue. You know what they don't teach you in law school? How to make money. How do you get clients? How do you get paid? Where do you learn those skills? Generally, on your first job. So you come and you work for me. You work for me for 2 years. You learn how to get clients. You learn how to get paid. You meet my clients. You work on their cases. You're good. 2 years go by, you quit. Now, in the employment contract, in this scenario, there was no covenant not to compete clause. So what do? You open up an office right next door to my office. I'm charging my clients $700 an hour for my services. You start charging clients $500 an hour for your services. My clients know me. My clients know you. They know you do good work, but you're $200 cheaper an hour. What do? They go to you. What happens to my business? I lose my business because I lose my clients, because one of the real hard jobs in law is getting clients. Now, had I included that covenant not to compete clause that said that you may not open up a law or related practice in a 5-mile radius of this office for 5 years, I probably would have kept most of my clients. You move 5 miles away, you open up your office. Some of my clients find out that you're leaving. They like you better than me, so they move with you. Some, but not all. If at the end of 5 years you move back next door to me, you've got your own clients, I've got my own clients, and now we have an equal chance of taking each other's clients. But the baseline is, or the bottom line is, I protected my business. In both instances, whether buying an existing business or an employment contract, a covenant not to compete is designed to protect actor 1 from actor 2 and their business interests. In both instances, when a covenant not to compete is unreasonable, a court may convert its unreasonable terms into reasonable ones or void them completely. Going back to example number 1 with the bodega, had the purchase contract said you may not open up another bodega or related business in the state of New York for 25 years, that would have been unreasonable with regard to both scope and time. 20 years is too long to block a person from doing business, and the entire state of New York is too large of a region, right? So the court would likely void that in its entirety. In the second one, the employment contract, where it stated upon your termination of employment from this firm, you may not open up a legal or related practice in a 5-mile radius of this office for 10 years, the court may have just modified that to 5 years to make it fair. The key to covenant not to compete is fairness for both parties. For both actor one, the initial person who's doing business with the second, and with the second actor, right? You want the second actor to get value of what they're buying or value from their employment. But by the same token, you do not want the first actor to lose their livelihood or their ability to earn a living. Unconscionable contracts or clauses. In some circumstances, bargains are so oppressive that a court will relieve an innocent party of part or all of the contractual duties. Now, there are two types of unconscionability. The first is procedural unconscionability. Procedural unconscionability concerns how a term becomes part of a contract. Let's say that you leave school, you've got your MBA, you started your own company, wickedly successful, and part of your success is your efficiency. You and your assistant, your executive assistant, have been working as a team now for 15 years. You trust your assistant trusts you. And you have a routine that you guys have put together over the time you've worked together. Every morning when you come to the office before you start dealing with clients, you dictate all of the documents that have to be prepared, all the things that you have to sign and send out. After lunch, generally while you're on the phone talking with clients, your assistant brings the documents in for your signature. Your assistant's very efficient, so there's always a sticky label with an arrow pointing to where you have to sign. Now, your assistant's been working with you for a while and really wants to raise. So what does your assistant do? Your assistant slides a raise authorization form into the documents that you have to sign without you knowing. Now, because you guys have worked together for so long, you don't even bother to look at what you're signing because you know how good your assistant is. You sign the documents, your assistant files the documents or sends them out as they're meant to be. And lo and behold, you're suddenly paying your assistant not $75,000, but $150,000, and you've authorized that raise. That would be an example of procedural unconscionability. The document was snuck in. You didn't know how, or you didn't know anything about it. You were tricked into signing it. The second type of unconscionability is substantive unconscionability. This describes contracts or terms that are oppressive and deprive one party of the benefit of the agreement or leave the party without a remedy for non-performance. Now, to my mind, I think about the labor negotiations between Amazon and their employees. While Amazon is a fantastic company in terms of getting products from consumers, or to consumers, not from consumers, but to consumers, they're not that good with the benefits they give their employees and how they deal with them. Now, prior to the coronavirus, you had a lot of people who needed jobs. You had a lot of people who weren't making a living wage. So Amazon did not have to negotiate. Now, one of the things you guys may remember, folks wanted to unionize so they could get better pay, better benefits for the hard work they were doing. Amazon refused to budge. Take it or leave it. Why? Amazon, great big super company, one of the most powerful companies in the world. And what's an employee? A little teeny person. Uneven bargaining power, right? So they really were deprived of all the benefits of working. Yes, you make money, but you work like a slave for 12 hours. You get 30 minutes for lunch. You get no breaks. If you go to the bathroom for too long, you can be docked 2 or 3 times. You can be fired. Unfair, but the bargaining position was uneven. That would be substantive unconscionability. What the contract actually states that makes it unfair. Exculpatory clauses. An exculpatory clause is a clause in a contract where one party relieves another party of liability for harm caused by negligence or other wrongdoing in advance. Hold on to in advance. Generally, they are held to be unconscionable contract clauses because they attempt to absolve a party of negligence or other wrongs. Now, here's the thing. When you absolve somebody of liability for a harm caused by negligence or another wrong in advance, basically, you're giving them a green light not to do a good job, not to do what they promised to do, not to exercise an appropriate standard of care. Why? Because in advance of anything happening, you are telling them you will not sue them. Exculpatory clauses are unfair because if you think about it, why do people do what they promise to do under contract? Tell you why. Because if they don't, they can be sued. Now, unconscionable, unfair, think about this. When you go to a hospital, you go to the emergency room, what do they make you sign? They make you sign a waiver. What does the waiver generally say? If you are injured or die while in the hospital due to their treatment or lack thereof, the hospital is not liable. Now, when you go to the hospital for an emergency, you don't have a choice. You have to sign. If you don't sign, they won't treat. Now, here's the thing. Don't worry about it. Sign it. Why? First, it's an exculpatory clause. You're waiving liability in advance. Law doesn't let you do that. Second, you're signing under duress. You're doing something that you did not truly want to do, but you had no choice. Not fair, not fair, not fair. So you say to me, Professor Claire, why would hospitals have you sign waivers if the waivers have no meaning? Well, here's the thing. In the off chance someone goes to sue them and hospital says you can't sue, you signed a waiver, and they say, oh, damn, you're right, and they walk away, it's worth them having you sign 100,000 copies, 1,000,000 copies, in the off chance that one person does not sue. Right? So if you go to the emergency room, don't worry about it. Sign whatever you want. If they screw up, you get to sue them because it's not legal. It's contrary to public policy. Now, there's something that I want you to be very, very. An exculpatory clause is not an assumption of risk. Assumption of risk is a defense in the law of torts, which bars or reduces the plaintiff's right to recover against a negligent tortfeasor if the defendant can demonstrate that the plaintiff voluntarily and knowingly assumed the risk at issue inherent to the dangerous activity in which he or she was participating at the time of his or her injury. That's a mouthful, but think about this. Some of you may have played paintball. Some of you may have played football, basketball, or even tennis. Well, if you play organized sports, football, basketball, tennis, paintball, is there a possibility you can be hurt? Are these sports inherently dangerous? I have to say it to you, there are. They are. Not there are, they are. Football players tend to be big and fast. Basketball players tend to be very big and fast also. These are contact sports, right? If you get knocked down and you have a concussion or you break a leg, can you sue the guy that knocked you down? No. Because when you agreed to play, the document that you assigned, your waiver, your release, said that you assume the risk for injuries inherent in that activity. You're playing tennis. You've signed a waiver, a release to occupy the court, and you're saying you will not hold the owner of the court responsible if you were injured, hitting the eye with a tennis ball while playing, right? Because that's a risk. That's part of the game. For me, paintball, before they let you onto a field, you have to sign a waiver. You have to sign this release saying that you assume responsibility for any risks inherent in playing paintball. They also give you a brief and say, don't raise your mask in the middle of a game, right? If you raise your mask, they tell you explicitly that if you get hit in the eye with a paintball, it can blind you. right? I like skirmish at Woods Ball Field in Pennsylvania, right? And right away, I assume the risk of injuring myself while running through the woods playing the game. If I trip over a branch, if I trip on a rock, if I fall down, twist an ankle, that's on me because these are parts of the game. Now, for some of you, you guys go to baseball games. There's an assumption of risk on a baseball ticket. You assume the risk to get hit by a ball or broken bat, right? So if you have those good seats, a foul ball flies in, cracks you in the head, too bad, too bad, too bad. You can't sue. You've assumed the risk because that's part of spectating that game. Now, conversely, let's say you're in Yankee Stadium and you're sitting in the upper tiers and nosebleed seats and the structure fails. The area you're sitting in just crashes down and you fall. Guess what? You can sue them for that because being in a stadium falling apart in the middle of a game is not a risk ordinarily assumed while watching a game. Now, what are the effects of legality or illegality? In general, an illegal contract is void, but there are a few exceptions. Justifiable ignorance of the facts, members of a protected class, withdrawal from an illegal agreement, and a severable or divisible contract. Followed, of course, by contracts entered into through fraud, duress, or undue influence. Justifiable ignorance of the facts. A party who is relatively innocent can often recover benefits conferred under a partially executed contract. For example, a trucker who unknowingly delivers illegal goods may be able to recover the delivery fee. Now, please look at what I underlined, unknowingly. If the truck driver knew he was delivering illegal goods, well, not only could he not recover, he's also going to jail with the parties who sent the goods. But think about this. You're a truck driver for Best Buy. You go to your Home Depot. They load it up with all the boxes, TVs, going out to regional stores. Right? Within those boxes that are marked as flat screen TVs, there may be some illicit contraband, something you're totally unaware of. The cops have been tracking the people loading the truck, the smuggling group that's involved, of which you were not a part. They pull you over. They seize the assets. You don't make the delivery, but guess what? You can still recover your fees. Why? You did not know. 2, members of a protected class. If a statute is clearly designed to protect a certain class, a member of the class can enforce a contract in violation of the statute. For example, despite statutes limiting excessive working hours, an employee who works overtime can recover overtime pay. Think about this. Those laws were put in place to stop employers from taking advantage of employees. The laws say if you work more than 40 hours in a week, they must pay you overtime. Now, one of the things that's lovely, in recent years, we've also found out this applies not just to hourly workers, but also to salaried workers, right? The law says they can't do it to you, so doing it is illegal, but if they compel you to work, you can recover, you can be paid. Withdrawal from an illegal agreement. If the illegal part of a bargain has not been performed, a party can withdraw from the bargain and recover whatever he or she rendered in performance or value. For example, a bettor can quit an illegal bet before the winner is paid. This is an interesting example. Technically, it's correct. As a practical matter, I don't know if everybody else would let you out after you lose. Severable or divisible contracts. If a contract is severable and the illegal portion does not affect the essence of the bargain, the legal portion can be enforced. You see this quite a bit with construction contracts, right? Construction contracts tend to be severable or divisible. right? If someone hires you to demo a site and then build a house on the site, right? The contract has very distinct parts, right? The demolition is part one, the framing is part two, the running the electrical, the drywalling, the plumbing, and so forth. Each part is a separate part. Now, before you can do the framing, you have to complete the demolition and remove the trash from the site. So let's say you enter into a contract with somebody to clear up a site for you. They're going to demolish the house that's on it, build you another house, right? In it, you have the portion that you pay for demolition, the portion that you pay for disposal of goods. Now, in the disposal of the waste material part, you guys decide to dump the construction waste illegally. That portion of the contract is illegal. However, since the contract is severable, since each part of the contract is separate, that illegal portion does not affect the balance of the contract, right? So what does that mean? That means that the courts would not require you to pay for the illegal dumping or for even that person to do the illegal dumping, but they would enforce the rest of the contract, the demolition, the framework, the plumbing, the drywalling, the electrical work. All those things are separate. Now, there's something that I want you to remember. A contract is indivisible if the parties intend that each party's complete performance be essential, even if the contract contains a number of seemingly separate provisions. Now, where would you see something like this? You're a baker. I hire you to bake me a cake for my anniversary. Inherent in that contract are certain steps that you have to take, right? Step number one is acquiring or buying the supplies necessary to build or to bake the cake. All right, step number two is having the equipment necessary to assemble the ingredients and bake the cake. Step number three is in having the skill necessary to do steps one and steps two. Each are different steps. Now, even though you may be going to the store on Monday, buying special stuff for my cake on Tuesday, baking the cake on Wednesday, and delivering the cake to me on Thursday in your vehicle, all of these are seen as one seamless transaction, right? So that contract would be indivisible, right? Not perceived as being separate parts, because buying a cake from you, we don't explicitly state that all these steps must be taken to get the cake from your bakery to my house. Contracts illegal through fraud, duress, or undue influence. A party induced to make an illegal bargain by fraud, they were lied to, duress, they were threatened, or undue influence, they have no free will of their own, can recover for his or her performance. Right? And if you think about this, this one should be the most common sense. And I'm going to take you back to something we said when we first started talking about contracts. Entering into a contract is voluntary. No one can be compelled to enter into a contract if they do not want to. So if someone lies to you and tricks you into a contract, had you known the truth, would you have done it? Probably not. You can recover. If someone threatens you and forces you to enter into a contract, would you have done it without the threat, the duress? No, you recover. If you have no free will of your own, undue influence, and someone compels you to do it, your mother says, sign this document. Mommy, I don't want to. Do it. Why? Because I said so. Because it wasn't voluntary, you recover for your performance.